afternoon, everyone, and welcome to our webinar this afternoon on maternity and parental leaves for employees. My name is Jessica Steingard, and I am a staff lawyer here at the Centre for Public Legal Education Alberta, or CPLEA for short. We have a few other guests joining us today. I will introduce them in just a few minutes. Just go through some introductory remarks while folks are still joining us online. So the Centre for Public Legal Education respectfully acknowledges that we are located across Treaty 4, 6, 7, 8, and 10 territories, and we respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continue to enrich our vibrant community. This wouldn't be a legal webinar if we didn't have some sort of disclaimer. So this presentation contains legal information, is not intended to be legal advice. And I would also like to take a moment to acknowledge our generous funders who make presentations like this one possible. So we receive funding from the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation. A few other housekeeping items. We are recording today's presentation and we will be posting it on our YouTube channel within about a week. So you'll get an email from us when that recording is up. So if you missed something or want to go back, you'll be able to do that. We're happy to take questions at the end of the presentation. We'd ask that you put your questions in the Q&A box on your screen. You're welcome to put them in throughout the presentation, but we will get to them at the end, and we'll make sure that we leave 10 or 15 minutes to get to those questions. And finally, when you leave today, you're going to be prompted to complete a short survey. We'll post a link in the chat for you as well. Please take 30 seconds and fill that out for us. We'd love to know how we're doing and what other topics you might be interested in learning about. Okay, I'll go back to who we are. So I said we're the Centre for Public Legal Education Alberta, or CPLEA for short. And if you're not familiar with our work, our goal is quite simple, and that is to make the law understandable for Albertans. I guess I should say it's a simple goal, but it's maybe not so simple to carry out all the time. So we produce a variety of free, plain language information about the law. You can find our information in booklets, info sheets, videos, webinars like this one. We run several websites, and it's all free information. And our goal is to make the law available and understandable so that Albertans are empowered to actually use the law. They understand their rights and responsibilities and can do something about their situation. We are a nonprofit serving all of Alberta. So while our office is here in Edmonton, we do serve all of Alberta. This is our website, cplea.ca, and this is where you can find most of our information. So while we're talking about employment, workers' rights today, we offer information on a variety of other legal topics as well. Okay, let's get into the meat of today's presentation. We have two awesome panelists who will be sharing with us today about maternity and parental leaves. So I'm going to start with Evan Oikawa. Evan is an associate lawyer at DLA Piper Canada's Labour and Employment Group. Before joining DLA, Evan worked at a boutique firm in Calgary focused on plaintiff side employment law. He also worked at the Employment Standards Department at the Ministry of Labour, handling employment-related legal claims and helping to mediate disputes between employers and employees. So welcome, Evan.
Thanks for having me.
Thanks for joining. And the second face on your screen is Melissa Moisey. Melissa is a director of complaints management for the Alberta Human Rights Commission. And she manages a team of human rights officers responsible for screening human rights complaints. So if you've called into the Human Rights Commission before to talk to someone, you may have connected with someone on Melissa's team likely. So welcome, Melissa. Thank you for coming.
Thank you.
So we have several questions that we're going to go through, and Evan and Melissa are gonna give us their take on it. So let's start with our first one. We'll start with kind of the basics. What is maternity leave and who can take one? And I'm going to ask Evan for you to start us off on this question.
Sure, absolutely. So thanks again for allowing me to participate. So basically, maternity leave, it is a job protected leave, a leave of absence from work that allows pregnant employees to take up to 16 consecutive weeks off work, starting up to 13 weeks before the estimated due date. This leave is an unpaid leave by employers. However, employees may be eligible for maternity benefits through EI if they meet certain eligibility criteria. And to be eligible for the job protected leave, the employee must be employed by the same employer for at least 90 days.
Perfect. And Melissa, anything to add?
Sure. So, if a pregnancy loss occurs within 16 weeks of the estimated due date, the employee is still entitled to maternity leave. And a bit about human rights. Under the Alberta Human Rights Act, there are 15 grounds protected from discrimination. So, we call these protected grounds or protected characteristics. And the protected ground that covers pregnancy is gender. The Act also makes it clear that whenever it protects a person from negative treatment because of gender, the protection includes, without limitation, protection from negative treatment because of pregnancy. So basically, what the Act does is prohibits employers from discriminating against employees because of their gender. And this protection extends to pregnant employees taking maternity leave.
Excellent. Okay, so who's for? It's for at this point for pregnant employees. It's an unpaid leave, like Evan said, but we also have this human rights element coming in, where an employer cannot discriminate against an employee who is pregnant or wants to take or who is eligible for a maternity leave. Okay, so that's one part of the leave equation we're going to be talking about today. So now let's fill in the parental leave part. So what is it, and who can take one? And Evan, I'll get you to start us off again as well.
Sure. So parental leave, it's another type of job protected leave. So this job protected leave allows new parents, including adoptive parents, to take up to 62 consecutive weeks off work, and this is to care for their newborn or newly adopted child. Uh, if the parental leave is being taken by the birth mother, it must be taken immediately following the end of the maternity leave. Or alternatively, it can begin anytime after the child's birth or the adoption date. But all parental leave must be completed within 78 weeks of the baby's birth, or in the case of adoption, the child's placement. The leave can be taken by either parent or it can be shared between them, and it is also unpaid by employers. And just like with the maternity leave, employees may be eligible to receive parental leave benefits through EI if they meet certain criteria. To be eligible for the job protected leave, the same with maternity leave, they must be employed for at least 90 days with the same employer.
And Melissa?
So, under the Alberta Human Rights Act, the protected grounds that relate to the parental leave portion of the leave are gender and family status. And family status is defined in the Act as the status of being related to someone by blood, marriage, or adoption. So, family status and gender protections extend to employees taking parental leave, regardless of which parent or both parents are taking the leave.
Perfect. Okay, so I'm just going to summarize this quickly because we've got now maternity leave and parental leave. And probably some of you are wondering, well, I thought it was a year, right? It's a common question. Well, it is common for a birth mother to take it for a year, but that's actually composed of two different leaves, both the maternity leave and the parental leave combined together. But it can also be that either parent can take the parental leave portion of the leave. I'm going to throw a question in a left field for you that I don't think I gave either of you beforehand. Can both, as Evan, you had said either parent can take parental leave. Can they take it at the same time?
They can, yes.
Okay, and both receive EI benefits.
Yes, provided the total amount of the leave it can't be more than the prescribed amount.
Right.
But yes, it can be taken at the same time.
Perfect. Okay. So I think it was 16 weeks for maternity leave and 37 weeks for parental leave, you said?
Yep.
Okay, perfect.
Correct. Yeah.
Melissa, anything to add?
The only, I think, caveat to that is if the employees, if they work for the same employer, the employer doesn't have to grant them leave at the same time, which
Right.
would be, I think, a pretty rare circumstance, but one sort of exception.
Right. Absolutely. Okay, so now we've kind of got the foundation of what is a parental leave, what is a maternity leave. Getting into kind of the nitty gritty here of what laws relate to maternity and parental leaves. We've talked about it a little bit, but just to be really clear, Melissa, I'll start with you. What laws pertain to these two leaves?
Okay, so I'll start by talking about the Alberta Human Rights Act. It's the anti-discrimination law in Alberta, and it applies to almost all Alberta employers, except those that are federally regulated, like airlines, banks, or federal government departments, which the Canadian human rights applies to. So the Alberta Human Rights Act broadly recognizes the equality of all people, regardless of their gender or family status. And although the Act outlines these broad principles, it doesn't say anything specifically about maternity or parental leaves in the same way that some other laws do. But what it does say that applies to these situations is that employers cannot discriminate against employees because of gender, which, as I mentioned, includes pregnancy, or because of their family status. And so, through previous human rights complaints, the courts have set out the test for what discrimination is, and it's a three-part test. So, first, the person has to have a protected characteristic. For a pregnant employee, that characteristic is gender. For someone who has become a parent, that characteristic is family status. The second part is that the person must experience negative treatment in one of the areas protected under the Act, like employment. So, an example would be being fired or demoted. And the third step of the test is that the protected characteristic needs to be a factor in the negative treatment. So it doesn't have to be the only factor or even the main factor to be discriminatory. It just needs to be one factor, or in other words, it just has to make up any part of the reason for the negative treatment to be considered discrimination. So, really, when the Act says an employer can't discriminate against an employee because of their gender or family status, this means that they can't terminate or demote an employee because they plan to take maternity or parental leave. This also includes an obligation to return the employee to the same or an equivalent position after their leave. And employers also can't harass or negatively change the terms of employment because somebody is taking these leaves or because they're pregnant. And if someone believes that their pregnancy or family status is connected to negative treatment in the workplace, then they might have grounds to make a human rights complaint.
Perfect. And Evan, a few other
Yes. Yes. So as Melissa outlined, the Human Rights Act is sort of one of the key pieces of legislation related to maternity and parental leaves. And there's sort of a body of case law that Melissa discussed that sort of interprets how the Human Rights Act applies in situations of discrimination in pregnancy and parental leave. In addition to the Human Rights Act, there's also the Employment Standards Code in Alberta. That's another important piece of legislation related to these leaves. And that legislation essentially outlines things like your eligibility, duration, and conditions for taking a maternity leave or a parental leave. And so basically those job protected leaves, which are set out under the legislation, they allow employees to take time off without fear of losing their employment. So the employment standards legislation is an important piece of legislation in that respect. In addition, there's also the Federal Employment Insurance Act, and that legislation basically sets out benefits that employees can be entitled to if they meet the criteria that's set out in the legislation. And basically, that legislation is designed to provide financial assistance to parents during their leave so that they can take care of their child. So those would be the three key pieces of legislation that would relate to these types of leaves.
Perfect. Thank you both for describing those. So we think of, a maternity leave, I'm just going to take a maternity leave or parental leave, but it actually encompasses a few different aspects. Like we've talked about the human rights aspect, how your employer can treat you and not discriminate against you, the taking a leave, a job protected leave, so your employer can't terminate you because you are on this leave. And then also the financial benefit side of things under employment insurance. So we see, like Melissa and Evan have described, these three pieces of legislation coming together, and they all have a part to play in something that we sort of, I won't say take for granted, but in something that's just kind of so, commonplace. We just think of a leave, but it actually has a lot of different legal implications. So hopefully that gives everyone an understanding of how a leave is actually made up and where all these different rules come from. So we'll talk about these different components, simultaneously throughout the presentation. But we want to make sure you had a good foundation of knowing where these rules come from. So I got ahead of myself earlier when I asked about parent sharing leaves, because I forgot we did have a question on that. So how do parents share parental leave? So this would be either sharing it at the same time or else one parent taking part of the leave and one parent taking the other part. And Evan, I'll start with you.
Okay, yes, so as Jess mentioned, parents can share the parental leave. Under the Employment Standards Code, they're required to advise their employers of their intention to share the parental leave. So under the code, they can divide the total allowable leave up between them, so that's up to 62 consecutive weeks. And they can choose to take the leave either at the same time or consecutively. But the combined leave cannot be more than the 62 weeks. And in addition, it must also be completed within 78 weeks after the child's birth or the adoption date in the case of adoption. So those are how the parents can share the leave under the Employment Standards Code.
Melissa?
Yeah, so the only comment I'd add from sort of human rights perspective is that sometimes employers might have stereotypical views about which parent should be taking the leave. And they might assume that the birth parent is going to take the leave and that the other parent won't. And so if an employer refuses leave to a parent because of this kind of belief that the other parent, should be the one caring for the child, or otherwise sort of harasses them or gives them a hard time about taking leave, this could also then become a human rights issue.
Perfect. I have seen, we've seen it where, a birth parent may take a maternity leave and part of a parental leave, and then the other parent takes the rest of the leave to care for the child. So there's definitely different creative ways to allow both parents to take time off if they choose to. So, and probably becoming a bit more common today than we've seen before. Okay, the golden question. How do I tell my employer that I shouldn't say I want to take a leave, but I will be taking a leave because you're entitled to it. So how do I tell my employer that I'm going on leave? And Melissa, I'll start with you.
Okay, so under human rights, there's no specific rules or timeframes for how or when an employee must tell their employer that they're planning to take a leave. So really, in that situation, it's up to the pregnant employee about when they disclose their pregnancy and how they do that and who they tell, so long as they meet the requirement of the Employment Standards Code to give 6 weeks of notice before starting leave. For the more sort of practical elements of how, it's understandable that an employee might be nervous about telling their employer that they're pregnant or planning to take a leave, but the employer has a duty to accommodate these leaves, which I'll talk a bit more about in the next question. But for now, I'll say that the accommodation process really works best when the employee and employer communicate openly and in good faith. And so the employee might want to tell their employer of their leave plans in writing so that they have that information for their own records. And from what we've seen in previous human rights complaints about pregnancy, providing this information in writing is a good practice to remove any doubt about whether the employer is aware that the employee is pregnant or not. And when it comes to a pregnant employee taking maternity leave, the employer can require a doctor's note to confirm the pregnancy and provide the estimated due date. So employees should be aware of this requirement and provide the information if it's requested by the employer. And some employees may choose to be proactive in providing this information to their employer to start the conversation about maternity leave.
Evan?
Yes, so I think Melissa gave a good summary of the requirements under both human rights legislation as well as the Employment Standards Code. The thing I would add is that if you're on maternity leave, you generally don't need to provide a separate notice specifically for the parental leave. And as sort of just a general, comment, in terms of the Employment Standards Code, when the code requires that, certain notice be given within a specific period of time, it's generally important that the employee wants to make sure that they provide that notice, because if they fail to do so, that might disentitle them from the job protected leave. So that's something that's important to keep in mind, when people are thinking about taking these types of leaves.
Okay, another curveball question. Is there a caveat for someone, say they have to take, let's say if they have to give 6 weeks notice of the leave, but something happens and suddenly they're going on leave tomorrow or today. Is there a caveat for those kinds of emergency situations where I haven't given my 6 weeks notice, but suddenly it's an emergency, I need to go now?
Yes, there is a caveat in the legislation about that. I believe you might know off the top of your head, I believe it's that the employee has to provide a medical certificate within a certain amount of time. And if she provides that medical certificate, she's still entitled to the leave, despite the fact that, she didn't give the 6 weeks written notice that's otherwise required.
Melissa's nodding her head. Anything to add on that?
No, thanks.
Okay, perfect. So I just wanted to throw that out there to make sure, if things don't always go as planned. And so there is these emergency contingencies as well in the legislation. The other practical question I'm going to ask, and this is not necessarily something that the legislation will say, but more practically speaking, who should I tell? My direct supervisor, HR? Any suggestions? Either one of you?
I would say either of those would be okay. A direct supervisor is probably a pretty good place to start. But again, human rights law wouldn't say anything sort of as specific as that. But, it should be someone in the workplace who has the ability to do something about it, as opposed to your colleague.
That might be
I
Sorry, go ahead,
agree
Evan.
with that answer. Oh, sorry, I was just saying I agree with that answer. I think the employee can provide it to whoever they're comfortable with, but legally, I mean, as long as they provide it to a supervisor, HR, that satisfies what they need from a legal perspective.
And we haven't really talked too much about employment policies as well, but it might be something to check as well and see what your employment, if your employer has an employee handbook or something, if they say anything about who these requests should be made to as well. Okay, I know Melissa's itching to get to this question too. What are an employer's obligations before, during, and after a leave? Melissa gets a bit of a start already.
Okay, so the first obligation before leave is that employers have a duty to accommodate employees protected by the Act to the point of undue hardship. And so this includes accommodating pregnant employees prior to maternity leave. Accommodation means making changes to job duties, schedules, break times, as examples, to eliminate or reduce any negative impact that someone faces at work because of pregnancy. So While an employee's pregnancy may prevent them from doing part of their job, this doesn't mean that they can't or shouldn't continue to work with some kind of accommodation. Any accommodation provided by the employer needs to be reasonable based on the circumstances and whatever the employee's pregnancy related limitations or restrictions are. But it doesn't need to be the employee's preferred accommodation or a perfect accommodation. And accommodating someone to the point of undue hardship means that employers are expected to bear some hardship in providing accommodation. It's not enough to say it's inconvenient to accommodate or it's difficult to accommodate. It's a high bar for employers to meet, and undue hardship only occurs where the accommodation would cause a serious business disruption, onerous financial costs, or a legitimate health and safety risk. So most pregnancy accommodations, like need to be able to lift a little bit less or maybe be on your feet for a limited period of time, are very unlikely to cause undue hardship in the workplace. Um, Other examples of accommodation could include a medical leave of absence if a doctor assesses the person as unable to work for a period of time during their pregnancy, or a modified shift schedule to help manage morning sickness or other pregnancy related symptoms. Accommodations are always based on the pregnant employee's doctor's assessment, not based on what the employer thinks the employee can or cannot do. So that's sort of the before the leave piece. And the after the leave piece is that an employer has an obligation to return the employee to the same or an equivalent position at the same pay. A person on maternity or parental leave is still an employee. And so if they want to return early from their leave, the employer has an obligation to return them to work so long as they provide the 4 weeks of notice in writing that's set out in the Employment Standards Code. Also, after leave, it may be the case that parents have breast or chest feeding, childcare, or other family status obligations that require accommodation from the employer. And the employer has a duty to accommodate what are the legal obligations of providing care to to children. Family status accommodation is a fairly complex and developing area of human rights law. So it's there's a lot of it depends on what accommodation looks like. But some examples of accommodation could be providing space for a nursing parent to express and store milk, or modified shift schedules based on childcare needs. Um, an employee might have a preference to return to work part-time after parental leave, and that's not likely something that an employer would have a duty to accommodate under human rights law if it's based on a preference.
Evan?
Yes, so I think Melissa gave a really good summary of the obligations as they relate to the Human Rights Act. So the other main piece of legislation where some obligations are going to flow from is, of course, the Employment Standards Code, and there's sort of some overlap between the obligations in the code and the Human Rights Act. So the two main obligations under the code would be that the employer is prohibited from terminating the employee's employment during the leave unless the termination is unrelated to the leave or the reasons for leave. The other big obligation is that the employer must return the employee to their position when they're ready to return to work. They must be returned to their position or provided with alternative work of a comparable nature, and at not less than their previous earnings and benefits. So those are two important obligations under the Employment Standards Code. In addition to that, under federal legislation, when there's an interruption in earnings, such as when an employee is going on leave, there's also an obligation for the employer to issue a record of employment. So those are some of the obligations that would flow from those different pieces of legislation.
Perfect. Thank you. So we're going to dig a little bit deeper into a comment both Melissa and Evan have made about this employers not usually being able to terminate an employee during a leave. We said there may be some exceptions to that, but what if it happens? What if an employer does terminate an employee before or while they're on a leave? And Melissa, I'll start with you again.
Yeah, so that question and whether it becomes a human rights issue or maybe an employment standards issue depends on the reason for termination. So, human rights law, as I've said, says that employers can't terminate an employee because of or in connection to their pregnancy or family status. But on its own, it's not a violation of the act to terminate someone while they are pregnant or while they are on leave or planning to go on leave. But it is a violation of the act to terminate someone because of pregnancy or because they're planning to take leave. And as I said before, it doesn't have to be the whole reason, it just has to be part of the reason to be discriminatory. So the question we'd be looking at through a human rights complaint is what was the reason and was it connected to the pregnancy or the leave? If a person has reasonable grounds for believing their leave or their pregnancy was a factor in the termination of their employment, then they would likely have grounds to make a human rights complaint.
Evan?
Yes. So as Melissa kind of alluded to, of course, if an employee is terminated while on leave, one option may be to file a complaint through the Human Rights Commission. In addition, employees also have the option to file a complaint with the Director of Employment Standards for breach of the job protected duty. And a lot of the considerations, I think, under both types of complaints are similar. As Melissa said, if the reason for the termination is unrelated to the leave, then that is something that's legally permitted. Some tribunals have said that if an employee is terminated while on leave, that creates a presumption that the leave was at least one of the reasons for the termination. And then the onus might shift to the employer to then show that there were some legitimate reasons for the leave that were unrelated to a human rights ground or the job protected leave. So if the Director of Employment Standards or Human Rights Tribunal finds termination was contrary to the legislation, there's certain remedies they could grant to the complainant. So the Director of Employment Standards, they can award loss compensation. They can also order reinstatement of employment, although we don't really see that happening. At least I've never seen that happen since I started practicing employment law. So I think that's a very rare thing to see, but technically that power exists under the legislation. Then with the Human Rights Tribunal, it's similar. They can award loss compensation, they can order reinstatement, and they can also award general damages for injury to dignity resulting from the discrimination. So Employment Standards and Human Rights Commission, those are kind of the two avenues that employees can seek if they believe they've been terminated wrongfully while on a job protected leave.
Perfect. Thank you both for sharing those great answers and practical tips for someone who may be in this situation. Okay, we've focused a lot on human rights and employment standards. We'll jump over into the EI world for this question. So who can get EI benefits while on leave and how do I apply? I'll start with you, Evan.
Okay, so there's certain criteria set out in the legislation in order to be eligible for the benefits. So the criteria are that you must have paid employment insurance premiums through your employment. You must have accumulated at least 600 insurable hours of work in the 52 weeks before the start of your claim or the start of your last EI claim, whichever is shorter. Thirdly, your normal weekly earnings have to have decreased by more than 40% because of the leave. And then finally, you need to be a resident of Canada. So if you can satisfy those criteria, then you'll be eligible for the benefits. One important thing to keep in mind is you need to be paying the EI premiums through employment. So people like independent contractors or self-employed employees wouldn't normally or by default be eligible. They can opt into the EI program, but it's not by default. So that's something that's important to keep in mind because some people might not realize that. They might think they're eligible when they're not. In terms of applying, you could submit your application up to 12 weeks before your expected due date or the date that you plan to take your mat leave. And you should apply for the benefits as soon as possible, even if you don't have a record of employment. And you should file within 4 weeks of the last day of work at the latest. So it's important, and you want to make sure you don't lose any entitlement to the benefit. And then finally, you can apply for the benefits online.
Melissa?
Yeah, I'll just add one point that the employer's duty to accommodate an employee's leave to allow that absence from the workplace, that exists independently of whether or not someone qualifies for EI benefits. So the employer's obligation is to allow that absence from the workplace and return the employee to work after the leave, even if for whatever reason they don't qualify for EI benefits.
Perfect. I'm going to see there's a question. I know I said I wouldn't get to the questions until afterwards, but I'm going to tie this question together with the previous question about entitlement to the leave under employment standards. So Evan, as you were saying, entitlement to EI benefits, there's a certain number of hours you have to work to be eligible to be paid EI benefits. It's one of the criteria, right? And that is different from the eligibility under the Employment Standards Code of working for the same employer for 90 days to be entitled to the job protected leave. So there's two different criteria for these two different elements. To be entitled to the leave, you have to work 90 days, but to get EI benefits, there is a certain number of hours you have to accumulate as well. So it can get confusing.
Yeah, yeah, that's absolutely correct. So it's essentially two different pieces of legislation and two different eligibility requirements. So one is the eligibility for the job protection so that you can take the leave without fear that your employment will be terminated. So that's under the provincial employment standards legislation, which has its own eligibility requirement. And then separately, there's the ability to apply for the wage benefits, and that's under the federal legislation, and that has its own separate criteria for eligibility. So yeah, it can kind of be confusing, but that's kind of how it's set out in the legislation.
Perfect. Okay, another popular question. Does an employer have to cover health benefits for an employee on leave? So this is assuming that one of the parts of an employee's compensation while they're working is that they're entitled to health, is that they get health benefits, whether they pay the premiums or not, or their employer does. So do those continue while they're on leave? Melissa, I'll get you to start.
Yeah, so this is a complicated question with a complicated answer. So I'll just ask everyone to bear with me. The short version is that an employer is required to provide whatever health benefits they offer to employees in a non-discriminatory way. So employees on maternity or parental leave should have the same access as employees on other comparable leaves. And then the long answer is this. So there's these different parts of the leave. The first part of the maternity leave is basically a medical leave, the time it physically takes to recover from childbirth. This is often 6 weeks, but it can be longer, as set out by the employee's doctor. The rest of the maternity leave is a voluntary absence, as we discussed, only available to the birth parent. And then the rest of parental leave available to either parent is also voluntary. Because all of these leaves are unpaid, and because an employer who offers health benefits does so as part of a compensation package, it might lead you to think that the employer doesn't have to cover health benefits for an employee on an unpaid leave because they're not being compensated and benefit premium payments are a part of compensation, like Jess said. Could be 100% employer paid, could be split 50-50 between employer and employee. But like most of human rights law, it's sort of not that simple. So, employers are required to continue to pay employee benefit premiums during the medically required portion of the maternity leave if they normally pay for employee benefit premiums when their employees become ill or injured. So basically, the first part should be treated as any other medical leave. Employers often continue to pay for premiums during medical leaves, and so they often have an obligation to continue to do so during this medical portion of the maternity leave. For the other parts, the voluntary leave, employers are required to continue to pay benefit premiums only if they do so for employees on other types of voluntary unpaid leave, like personal leave, or if they allow for educational leave or sabbaticals. As it's less likely that employers continue to cover benefit premiums during those leaves, it's less likely that they'd have an obligation to continue paying their portion of the premiums during the voluntary portion of maternity and parental leave. But even if they don't have an obligation to continue paying their portion of the premiums, they should still be giving the employee the option of remaining on the benefit plan and paying 100% of the premiums themselves. They are still an employee, and if all employees have access to the benefit plan, then employees on maternity or parental leave should have access to the benefit plan as well.
Perfect. Evan?
Yeah, the only thing I would add is that in Alberta, our employment standards legislation doesn't expressly state or require that employers must continue the benefits for the employee while they're on leave. That's different from other provinces like Ontario, where it is expressed in that legislation. I think in practice, most employers will continue the benefits because, as Melissa noted, the employees continue to still be employed during the leave. And as Melissa noted as well, notwithstanding that in the Act, there's no express requirement in the Employment Standards Code, there may still be that requirement under human rights legislation to continue in certain circumstances.
So this is our favorite answer to questions, right? It depends. And it can be complicated. So if you have questions, this might be an area where to talk to your employer, or if you are concerned about it being a human rights issue, then to call the Human Rights Commission as well to get some clarification on whether or not it might be an issue. Okay, our last formal question. What if I need more time off than the leave allows for? So this, A, if you want more time off, but B, also to maybe for Melissa and Evan to cover in your answers, we see now EI offers these extended benefits up to 18 months. How does that interplay with the job protected leaves set out in Employment Standards Code as well? And Evan, I'll get you to start.
Okay. So in terms of answering this question, employees certainly can discuss an extended leave with their employer. However, if the employer agrees to it, then it may be without pay, and the employment insurance benefits might only cover a specific time frame. So there might be a period of time where the employee is not able to continue to receive the EI benefits. Under certain circumstances, the employer might be required to consider extending the leave as a reasonable accommodation under human rights legislation. So for example, if there are extenuating medical or family-related reasons, that might be a basis for that. But if an extended leave would cause undue hardship to the business operations, in those circumstances, the employer may not be obligated to allow for it. But as Melissa mentioned, the undue hardship is quite a high bar to meet in many cases. So yeah, that's kind of my thoughts on that topic.
Melissa?
Yeah, so while they do have that obligation to accommodate an extenuating, maybe family status situation or a disability related inability to return to work, there's no obligation under human rights law for an employer to accommodate someone's preference for extra time away. So if that's what it is, I'd just like to spend a bit more time at home, that's totally reasonable, but not something that employers would have a duty to accommodate under human rights.
And then going back, so the 18 months that someone can take under like the extended benefits, you can get 18 months of extended benefits now. If that is longer than the time you're allowed under Employment Standards Code, how does that work? Is my job still protected for that full 18 months, or is that the job protected leave has now ended and now it's a separate negotiation with your employer as to whether or not you can take the additional time off? Any thoughts on that, Evan or Melissa?
Yes, I think it would be the latter off the top of my head. So I think the general idea is that the Employment Standards Code is intended to sort of mirror the federal legislation. I'm not sure off the top of my head if they've caught up with that additional change. Jess, you might know. But if they haven't, then basically that period of time might not be job protected under that legislation.
Yeah, I believe the Employment Standards Code has caught up with that 18 months of job protected leave. If you do 62 weeks plus 16 weeks of maternity leave, I think that takes you to 18 months.
Yeah.
And even though parts of those leave are voluntary, human rights would still require an employer to accommodate the entire portion, whatever it is that an employee is entitled to under employment standards or employment insurance law.
I will throw another time frame in here. Employment Standards Code, I believe it's in the Employment Standards Code, a birth parent is normally required to take at least 6 weeks off. And if you want to return to work within 6 weeks of giving birth, I think you have to have a doctor's note to allow you to return. So our law has kind of said, we're going to give this minimum 6-week period because that's, as Melissa had said earlier, that's usually the medical portion of a leave. That's the recovery time. And so if you want to come back sooner than that, then there is a requirement to get a doctor's note allowing you to return to work. Just another time frame to throw out there. Okay, so I'm going to open up the questions now. We have several questions in the Q&A, so we'll start going through those. So 60 weeks or 16 weeks, it was a little hard to hear. So I'm going to clarify. So we have been throwing a lot of weeks around. So Evan, maybe do you want to clarify some of these different? There is a 16 weeks. There is a 62 weeks.
Yeah, sorry, I can't see the questions on my screen.
Oh, if I just hit answer live, does that help? Does it come up now for you?
I don't think so.
Okay, well, I'll frame it this way then. So there's 16 weeks, that's maternity leave. There's 62 weeks, which is the parental leave. So a birth parent could take 16 weeks plus 62 weeks, correct?
Correct, yes.
Okay. A birth parent may choose only to take 16 weeks, and then either parent may decide to split or have only one parent take the 62 weeks.
Correct, yeah.
Perfect. Okay, so to the person who asked the question, there was both. Okay, in order to be eligible for the maternity leave, the employee must be employed by the same employer for at least 90 days. Does the number of hours matter? We pulled that question in when we were talking about EI benefits. So for one leave, it does matter. For job protected leave, you have to be employed for 90 days, as Evan said. But in order to get benefits, there's a certain number of an hour threshold you must meet as well. And I don't, if Evan, if you still have that up, the number of insurable hours, do you have it off the top of your head what that was again?
600 within the 52 weeks prior.
And that's not necessarily with the same employer, correct?
Correct, yes.
So it can be with a few different employers. Someone's asking about the recording. You will receive a link via email to the YouTube when we post it on YouTube. So rest assured, we will be sending out the link to the recording. Okay, next question. If I am the non-pregnant parent, how do I know when to start my leave if due date isn't accurate, which, let's be real, they rarely are? And how do I message that to my employer? What can the employer request as proof? So this is as a for a parental leave. Evan or Melissa?
Yeah, so for parental leave, employees should be giving notice to their employers as soon as possible that they're planning to take leave. As for what they could request as proof, um, I suppose they could request something to confirm the birth of the child. I don't know if Evan has anything on that piece of
Uh,
it.
Under the legislation, there's no obligation on the part of the employee to provide any particular evidence. It's set out specifically with respect to the mother. So legally speaking, based on the code, to the last time I checked anyway, I don't believe there's any ability for the employer to request that information or the requirement to provide it, I believe, off the top of my head.
Yeah, and under human rights law, an employee has an obligation to participate in an accommodation process by providing information to their employer to support their accommodation request. But it's unlikely if the code doesn't require some kind of proof that we would require it through a human rights complaint.
So you're not having to give proof that, a child was born or that you've adopted a child. There's not necessarily that same requirement as there is to take a maternity leave, because when we talked about maternity leaves, there is a requirement to an employer can ask for proof that that the parent is pregnant and when their due date is.
Yeah, but usually for a parental or maternal leave, usually the proof they're going to be looking for is the medical certificate saying that the employee is pregnant and when the expected due date is. So that's usually the type of thing that you would use to substantiate that.
Mhm. Perfect. Question here about 4 weeks notice to return to work. I think we mentioned that under the Employment Standards Code, an employee must give 4 weeks notice before they want to get back to work. Correct?
Correct.
Correct. And as I kind of mentioned, it's important to make sure when there is a requirement to provide notice that the employee makes sure that they provide the notice and provide it in writing, because if they fail to provide it, employment standards may not accept that complaint, or they may reject the complaint if someone complains about not being returned to work. So very important to make sure employees follow those directions in the Employment Standards Code.
Perfect. Okay, does an employer have an obligation to accommodate prenatal doctor's appointments? Do I need to use sick days if I have them, personal time off, or take unpaid leave for these appointments?
Yeah, so the employer does have a duty to accommodate medical appointments, but they wouldn't have an obligation to pay for that time. If you do have paid sick leave or appointment benefits, you should be able to access those to attend medical appointments or unpaid leave if you don't have those entitlements as part of your employment. And the employer generally can ask an employee to try to schedule the appointments in a way that limits the interference with work, which isn't always possible. Sometimes you get the doctor's appointment you get, but it generally is seen as reasonable for an employer to ask the employee to try and schedule them in a way that doesn't interfere as much with work.
Perfect. Anything to add on that one, Evan?
No, I think that covers it.
Perfect. Okay, if an employee is on short-term disability due to pregnancy prior to birth, can the employer end their short-term disability coverage once the child is born if they provide an EI top-up program?
Yeah, that's part of that benefit coverage is very complicated answer. Um, Employees should be able to access short-term disability or medical leave prior to the birth of the child. And if they do have some kind of top-up program above EI benefits that that is because of illness or the time it takes to recover, then they should have access to those benefits after. But short-term disability generally would only go up until when the child is born, and then it switches over to maternity leave. But then they would have to meet whatever criteria it is that sets out the top-up benefits from the employer. Whether that's a doctor's note is often the case, but something like that. So it's sort of a separate thing, even though it might flow from the same medical absence into maternity leave.
And we didn't really talk about that too much, but we have these EI benefits that the federal government has, their EI program that pays out maternity leave benefits as well as parental leave benefits. And some employers do offer a top up, but that is not required and is only a perk that certain employers can choose to provide if they wish. So some people may get it and some employers may not offer that. So it's not required though. Okay, can you give an example of a termination that relates to maternity leave, and how does terminating an employee's position, where would that fall in terms of wrongful dismissal? Termination occurred during the duration of mat leave. And Melissa, you've already answered there. Terminating an employee's position completely.
Oh, that wasn't me. I think a different Melissa.
Sorry, different Melissa. Okay. So let's go back to the question. An example of a termination that's related to maternity leave.
Yeah, so a common one that we see is that an employer hires a temporary replacement for an employee going on maternity leave. And then maybe they like that employee a little bit more or think they're doing a better job than the employee who went on maternity leave. And so they decide to terminate the employee on leave and keep the employee that was hired as a temporary replacement. And so it is only the employee's absence from the workplace that has led to this termination. An employer might be able to demonstrate that there were performance issues before the leave or that there were performance issues discovered during the leave to show that it's not connected to pregnancy. But when all it is the fact that this employee is absent from the workplace and they sort of decide they like somebody else better, that's likely to be a situation where there would be enough to show that the termination is connected to the leave.
Anything to add, Evan?
No, I think that's spot on. That's typically what I tend to see as well, where it's a termination, and like Melissa mentioned, where there's a temporary person that's brought in and then they continue to work. That's pretty, that seems to be strong evidence that the termination was related to the pregnancy. Or if, for example, the employee's terminated and the employer claims that it was due to lack of business, that's sometimes a common thing that's stated. But then you see, for example, the employer post a job posting for the same position shortly thereafter. That would be another situation where you could see that very likely the termination is related to the pregnancy and then potentially discriminatory and as well as a potential breach of employment standards legislation.
Okay, we have 2 more questions. I'm going to breeze through them in the last minute we have. If you're on a salary grid that goes up yearly, are you entitled to the next step on the grid at the appropriate time? I'm assuming if you're on leave at that time, for the percentage to be considered for EI benefits.
So this is it depends. If the salary increase is automatic and based exclusively on your years of service for the employer, then you probably should get the increase when you return to work. And so I'm not sure that it would be considered for the percentage of EI benefits, but when you return to work and you start being compensated again by the employer, then you should likely receive the increase on the salary grid. But if salary increases are tied to something else, like performance or sales, or they're not automatic, then it becomes a much more complicated question that would likely be something you'd need to seek some legal advice about.
Perfect. Okay, last question. For parental leave, what are the number of hours required for eligibility? Both, let's say, is it the same number for EI? And I'm already blanking, Evan, on what you told us. The 600?
Yeah, it's the same for the eligibility for maternity leave benefits, and parental would be the same under EI legislation. So it'd be the 600 insurable hours in the 52 weeks. That would be under the federal legislation. Then for provincial, for the job protected leave, that would just be based on the number of days. And provided you work those days, there's no minimum number of hours. It's just based on the days in that circumstance.
And that's the 90 days again.
90 days.
90 days. Yeah. Perfect. Okay. Okay. We covered all the questions. Thank you for that. Just a few closing remarks. I want to say a huge thank you, Melissa and Evan, for joining us today and sharing with us your knowledge on this topic. Hopefully those of you in the audience have learned a lot, as I have as well. So thank you very much. We appreciate it. And let's stay connected. So as I mentioned, CPLEA has a lot of information about a lot of different legal topics. So you can find that at our website, cplea.ca. We also have a newsletter that goes out monthly via email. So you can subscribe there, cplea.ca/subscribe, and just stay up to date on resources we have coming out and any changes in the law. And finally, find us on social media. So we're on Instagram, X, Facebook, YouTube, so you can find us there and follow along as we share different information. And the last thing I'll say is we have 2 more webinars coming up this spring. They are in May. One is about is home buying. So if you're interested, head over to cplea.ca/workshops to register for those ones as well. So we'll leave it at that. Thank you, Melissa. Thank you, Evan. And as I mentioned at the beginning, Matt's, I think we've posted a link in the chat for our survey. Please take 30 seconds, fill that out. Let us know how we did today. And we hope to see you again soon. And enjoy the rest of your Thursday, everyone. Thanks.
Thanks. Bye, everybody.
Thank you.